Hi, my name is Christian Maynard, and welcome to a breakdown of cannabis laws in Alabama. The information in this video is largely drawn from NORML, a national organization for the reform of marijuana laws. Alabama operates under a medical-only cannabis policy. Recreational cannabis remains illegal, and the state's medical program is still in a gradual rollout phase, meaning access exists in law but has been slow to fully materialize in practice. The list of qualifying conditions in Alabama is relatively extensive, but also tightly regulated. Patients may be eligible if they have conditions such as cancer-related symptoms like nausea, weight loss, or chronic pain, epilepsy, or seizure disorders, PTSD, Parkinson's disease, multiple sclerosis, Crohn's disease, sickle cell anemia, terminal illness. There are also broader categories including chronic pain that has not responded to conventional treatment. However, physicians are required to document that standard treatments have failed before recommending cannabis. This adds another layer of medical gatekeeping compared to some other states. Alabama takes a notably restrictive approach to how cannabis can be consumed. Patients are not allowed to access raw cannabis flower or edibles. Instead, permitted products include tablets or capsules, tinctures and oils, topical gels and creams, transdermal patches, inhalable oils via nebulizers, and possession is capped at 70 daily dosage, with dosage limits especially strict during the first 90 days of treatment. For minors, only low THC products are allowed. Home cultivation is not permitted in Alabama. Dispensaries are legally authorized, and as of 2026, they are expected to become operational. However, the rollout has been delayed and the system has faced administrative and legal challenges. Delivery services are not allowed, but caregiver provisions are in place, meaning that designated individuals may assist registered patients once the system is fully active. Alabama currently provides no explicit employment protections for medical cannabis patients. This means individuals could still face workplace consequences for cannabis use, even if medically authorized. Additionally, Alabama does not recognize out-of-state medical cannabis cards, so there is no reciprocity for visiting patients. Driving laws in Alabama distinguish cannabis from alcohol in an important way. The state does not require drivers suspected of cannabis impairment to submit to chemical testing. Testing is generally voluntary unless there is a serious accident involving injury. However, law enforcement can conduct sobriety checkpoints, and courts have upheld their legality when conducted under structured procedures. Cannabis consumption lounges are not permitted, and public use remains illegal. Outside of the medical program, cannabis possession is still subject to a criminal penalty, reinforcing that Alabama maintains a relatively strict stance compared to more permissive states. In summary, Alabama's cannabis policy reflects a highly controlled medical model with limited product forms, no home cultivation, and a slow implementation process. While legalization has technically begun, practical access remains a work in progress. Thank you so much for watching. If you'd like to learn more about cannabis policy, please get subscribed and like the video.